Good afternoon. My name is Keith Bray, and I'm the General Counsel with the California School Boards Association and the Director of the Education Legal Alliance. The Education Legal Alliance, the ELA, has some good news to share with you this afternoon. I have with me, to my right, is Diana McDonough with Fagen Friedman Fulfrost, who appeared before the State Commission on Mandates last Friday and came away with a big victory for our school districts and county offices of education and SELPAs here in California. To my left is Deborah Caplan. She's an attorney with the law firm of Olson Hagel Fishburn. Deborah is working with the ELA on a lawsuit that is also challenging action by the legislature in 2010-11 that we'll get to and show how it connects to the decision that the Commission on State Mandates made on Friday. Diane, you have some good news to share with us.
Yes, indeed. We had a wonderful day on Friday, and we were excited because the Commission voted 7-0, and school boards know a 7-0 vote doesn't happen every day. 7-0 that they should adopt a reasonable reimbursement methodology for the behavioral intervention plan's mandate. Now, in case you're not real familiar with what that is, let me just say the reasonable reimbursement methodology means a standardized formula. So the Commission voted to adopt our proposed standardized formula for reimbursement for all school districts and SELPAs and county offices in the state for implementing the Behavioral Intervention Plan mandate, which is a special education, very expensive mandate.
When was that mandate first made a mandate by the Commission, and the legislation was passed in 1993, the Hughes Bill?
So this legislation was actually passed in 93-94. The claimants who've been on this ever since 94, when they filed their claim, which was Butte County Office of Education, San Joaquin County Office of Education, and San Diego Unified School District. In 2000, the Commission rendered a decision that, in fact, this was a state mandate because, as you know, much of special education is driven by federal law. And if the federal law requires it, the state will not reimburse you for it. But if the state requires more than the federal law, they'll reimburse you for that additional amount. So in this case, in 2000, they decided, yes, this is a state mandate, more than federal law. And so then the question became, how much does it cost? Okay, it's more, but how much should people get for doing it? And things went back and forth. There was an appeal. We tried to settle it, so on and so forth. But ultimately, what we figured out, not to our surprise, was that this mandate cost $10.64 per every student in the state of California. So if you think of it this way, if we have about 6 million students in California and it costs $10 per kid, that's $60 million a year since 93-94. So broadly speaking, that was what happened on Friday.
And the Commission has almost like a tentative decision. They voted unanimously. They're coming back in April to finalize the decision because there was a bit of a wrinkle, wasn't there, on Friday in terms of how they dealt with the most recent 2 years?
Exactly, yes. A bit of a wrinkle, a heart attack for those of us that were sitting at the table, because we came in believing, based on what the staff had recommended, that the Commission was going to decide between two things: either to agree to a standardized reimbursement of $10.64 per ADA, or to require districts to file actual cost claims for every year. And you can just imagine what it'd be like to dig up cost claims since 93-94 for every single year for every kid that you gave this program to.
And that was the position of the Department of Finance?
That was the position of the Department of Finance. So we're sitting there, we thought those were the two alternatives, but lo and behold, the chair says, well, I want a third alternative. And my third alternative is going to be the the formula for some years, but then I want to switch over and do actual costs. And so what happened was we then began to realize it's going there, but as of what date are we going to have to file for actual
And my
costs?
recollection during the hearing is that you were pushing for June 30th, 2013, to get through the remainder of this year before the actual started.
We were hoping for that. We got June 30th, 2012. So we have to get ready to file actual claims as of this year. But still, we managed to hold on to having the uniform reimbursement of $10.64 per kid for every year from 93-94 to 2011-12.
And that's quite a victory. That can't be understated. Now, how is the State Controller's Office going to play a role in the future with respect to these claims?
We hope the role is going to be all good.
Okay.
But therein could lie some problems. So the next steps are that, as you mentioned, in April, the Commission will meet again to finalize, to actually adopt a decision. And that decision, we believe, we're confident, will be exactly what they said, which is the formula for costs through June 30, 2012, and thereafter, starting with this year, actual costs. Okay, you have to put in actual claims for costs. And then what the law says is that 90 days from the date or shortly thereafter of that decision, so 90 days from April 19th, around July 19th or thereafter, the controller will issue some claiming instructions. Here's the other wrinkle. The claiming instructions will include offsets.
Okay.
And that's the part that we were struggling with, which we were not completely successful on. The offsets have two parts. One area of offset is you can only claim behavioral intervention plan costs to the degree that you had local budget costs, commonly called encroachment, for special ed. If your special ed revenues completely covered your special ed program for a given year, then you will not be able to get your BIP claimed costs, even though you'd multiplied 1064 times your ADA and so on. But in almost every case, there is a local contribution, which ends up exceeding by quite a bit that BIP
What the
cost
state
amount.
provided. Correct.
So, and what you're due. So one would hope that in most cases, most people will be able to get their full cost. Now, that's part one about just general special ed offset. Then there's part two. This is more difficult, and this is where Deborah comes in. Part two offset is this. As of 2010-11, the state enacted an amendment to the Ed Code which said that BIP costs must first be paid for from special ed revenues. So the first thing you pay for from special ed revenues is not your special day class teacher's cost or your resource specialist cost. No, the first thing you pay for is the cost of this mandate. And so that really eliminates districts' ability to claim as of 2010-11. And that's part
And they did that in conjunction with finding that it wasn't a mandate, that it was simply federal law. And we know from the way the Commission handled that by not acknowledging the legislature's decision not to call BIP a mandate, that there's more to come on that. But why don't we talk a little bit about our lawsuit that we filed with respect to the 2010-11 Budget Act and how it relates to what the Commission decided on Friday. Deborah?
Well, as Diana just mentioned, in 2010-11 in the budget, the legislature did make certain changes to mandate law as well as certain changes to the Ed Code. And one of those changes had to do with funding for the BIP mandate. And what they required was, as Diana explained, was that basically you use your special ed money first for BIP. and that they deem that money to be in satisfaction of any mandate claims. So we have filed a lawsuit that was filed in 2011 on behalf of the Education and Legal Alliance and a number of county offices of education and school districts, challenging several aspects of the budget and the trailer bill last year. But as relates to this mandate in particular, we've challenged that language that the legislature enacted deeming special ed money to be required to be used for the BIP mandate first and not providing any new money. The argument is that that is unconstitutional, that it violates the provisions of Article 13b6, which require the state to actually reimburse local governments and school districts for the cost of their mandate. So if they can simply point to existing appropriations, then essentially they've gotten out of their obligations under 13b6. So we think that's unconstitutional, and we are hopeful that if we are successful in the Superior Court, then that will then have to factor back into the commission decision and hopefully reverse that aspect of the commission's decision going forward.
So presently we're in the Superior Court. We amended our complaint a couple of months back to include some of the machinations that occurred in the 2012-13 budget. But in terms of what you referenced, these offsets, the commission in its decision did accept those offsets, just not the general offset that you described that's going to cover every year going back to 93, 94. And that really can't be understated here. The tenacity of the claimants, again, San Diego Unified School District, Butte County Office of Education, and the San Joaquin Office of Education, and their representatives, many of which have been involved with this from the very beginning. The tenacity to go through with this and to get really a decision that's right for the districts and for our special needs children in California. But they did acknowledge in their decision this 10-11, 11-12, and onward in terms of how there might be then really an offset for districts that would not enable them to receive any additional dollars under their decision, right?
They did, but we stated, and they tacitly acknowledged, that we would amend these parameters and guidelines, which they were voting on, based on our current court challenge, assuming it comes out as we expect. And so that's what we would hope to do, is to amend it so that it's erased and people can claim for those years just as they could previously.
Okay. Now we know there's more work to do. You mentioned a hearing coming up in April where a final decision could be made, but there's also other steps that, and the state controller coming with claiming instructions that will be something that districts will be able to utilize efficiently. What about the funding of the decision that the commission made on Friday?
Yes, it does have to be admitted that while we're here, relishing this wonderful victory, we do need to say that what this amounts to is now sort of a certified IOU. What we now have is, assuming districts follow through and file their claims, we'll have a mountain of money owed to us for this claim. Could be close to $1 billion. And it will then be up to the legislature to fund it at some level. And we're just hoping that the kind of momentum that's been behind this and our sense that Governor Brown has an interest in addressing the state's actual obligations and not pretending that they don't exist. We're just hopeful that at least some of this amount will be paid off in the coming year and perhaps split up between 1 year and the following, but that this debt will come to be paid off.
Well, and the responsibility of the school districts, because that first claim is a doozy, right? It's going to take in, 19 years?
Yes, so let me mention what happens once the claiming instructions come to each district and county office. They will have 120 days to fill them out. And the first claim has to include the whole time period. So we're happy because for almost all of those years, you can use this standardized formula. But, well, I should say for all those years, you can use the standardized formula. But you do still have to do the formula calculations for each individual year. What was your ADA? What was your special ed revenue, your special ed costs, and your BIP costs? And run that all through to see what you're owed for each year.
Well, I think the discussion that we've had here this afternoon to help summarize and also to bring everybody up to speed on what the State Commission on Mandates did on Friday is really a good example of what the Education Legal Alliance brings forward for its members. And by bringing forward for its members, in this case, as you have been able to tell, represented by two of top attorneys in the state of California when it comes to education law, and fighting for the interests that we all support in public education in California. At times, that fight has to go into the courts of law. Other times, it's advocacy with the state legislature. Other times, it's simply rallying the community, as was done with the voters in Proposition 30. That all of that is the same sort of advocacy package. And the Education Legal Alliance, with its 700 members, we're here at CSBA very grateful for the districts and the county offices of education and the ROPs that have done so much to support the activities of the Educational Legal Alliance over the years. And I think the discussion today is a good picture of what can be a net result of those activities. So with that, we appreciate you being able to check in with us today and to get feedback on what the Commission on State Mandates did last Friday.